All right. Thank you for bearing with me. So there's been interest statewide and nationally regarding First Amendment and obscenity laws as they relate to public schools. So I've been asked to do this presentation. This is now the second time. So who can raise a First Amendment challenge? The district has a policy that addresses this. It's 9130. Any person or group having legitimate interest in the schools of this district may present a request, suggestion, or complaint concerning district personnel, the educational program, instructional or resource materials, or the operations of the school district. So from the School Ethics Act presentation, you know that the boards adopt these policies. This is one of those policies that they have adopted. Every school district in New Jersey has a similar policy like this with various small differences. To raise a concern or complaint, the party must have a legitimate interest in the schools of the district. This has generally been interpreted to mean with actual ties to the school. Generally, status as a township taxpayer is not enough to establish standing. There must be some more significant basis to establish legal standing. Requirements for standing usually include that the plaintiff suffered an injury in fact, so that the person that's claiming or making the complaint has suffered an injury that is fairly traceable to the challenged action of the defendant, and that will likely be redressed by a favorable decision. And again, those are court standing. It's not the same as what would be the standing for 9130. For example, a future plan to someday check out and read a book in question is generally not enough. There would have to be more of a direct connection than that. Individuals with the actual ability to check out the book who have attempted have standing to raise such complaints. This was decided in the case very recently, Little versus Llano County out of Texas. Students and parents of the district are examples of individuals who can utilize District Policy 9130. That is not the sole, or that's not the exclusive list of individuals that could use it. So standing in New Jersey, the South Orange Maplewood Board of Education implemented a policy on how books are selected and how the public can challenge books that appear on library shelves. That policy states only a student or parent guardian of a student in the district can make a challenge. So there are differences from one school district to the next. That was one of the differences. The goal of the policy was to have complaints brought by a stakeholder. Does the First Amendment permit schools to censor library books? This is a question that has been asked recently. The answer is yes, it does. Pursuant to the United States Supreme Court Board of Education versus PICO, schools are permitted to censor library book. Local boards have substantial legitimate role to play in the determination of school library content. PICO is an interesting case. So just briefly, when you think about courts, and everyone has heard of the United States Supreme Court, that is the highest ultimate authority in the land when it comes to the interpretation of laws. Before the United States Supreme Court, in the federal jurisdiction, there are what are called circuit courts. And so New Jersey is part of the Third Circuit, which governs a handful of states in the area. New York's in the Second Circuit. Pennsylvania is also in the Third Circuit. And then below the circuit courts is the federal district court. That's the first layer in the federal system. And many cases involving interpretation of the United States Constitution and the First Amendment, which is part of the Constitution, go through the federal system because the Constitution is federal. In New Jersey, we have a similar three-level court system, the first court being the Superior Court, the second court being the Appellate Court, and then the final being the New Jersey Supreme Court. We will also, in New Jersey, touch upon issues that get into the First Amendment. It kind of depends on how the person initiated the case and whether anybody took action during the course of the case to remove it to federal court or not. So you'll have cases from time to time that are specific to New Jersey. Many cases, though, involving the First Amendment come from federal jurisprudence because federal supersedes state in most areas. So what rights do students have? Students must always remain free to inquire, to study, and to evaluate, to gain new maturity and understanding. The school library is the principal locus of such freedom. So this case, PICO, was a U.S. Supreme Court case, but it didn't have a majority. It's the case that everyone goes back to and cites when they start talking about First Amendment when it comes to censorship and books and other media and art materials when they're in the public area. At the same time, though, because it didn't have a majority, it doesn't provide clear controlling guidance for anyone else, meaning lots of other courts have expressed that they can deviate from it, and they have deviated from it at times. School districts do not have absolute discretion to remove library books. That has been held pretty consistently throughout the appellate courts. So when does district discretion apply? Our Constitution does not permit the official suppression of ideas. That's at the fundamental core of the First Amendment. Essentially, the idea is that let's let people speak, and then the marketplace of ideas will figure out which one the best is, and we'll go from there. And so for the most part, that's why in the United States particularly, as compared to many other countries, the freedom of speech is sacred. If we asked anybody in here, including myself, what amendment comes to mind when you think of the amendments? Freedom of speech is probably the first one off your tongue. Courts will look to the motivation behind the book suppression. So if there is a decision to remove a book from a school library, they're going to say, well, why did you do it? What's your reasoning? What's your rationale? You have to have rationale for it. Denying books because they contain ideas that a district does not agree with constitute a violation of the First Amendment. That has been consistently held throughout the country. So when does district discretion apply? If books were removed based on educational suitability, then removal is perfectly acceptable. Educational suitability could be age appropriateness. It could be whether or not it is consistent with the curriculum. Those are reasons that something may or may not come and be excluded from a library. Courts have found vulgarity and obscenity to be a valid basis for removing books as well, although we'll get into the definitions of what exactly that means. Ultimately, school boards may not remove books from school library shelves simply because they dislike the ideas contained in those books. And that, again, is at the core and fundamental to the First Amendment. So what is obscene speech? Obscene speech is sexually explicit material that violates fundamental notions of decency, which are great words from a U.S. Supreme Court that everyone then has to interpret and figure out what it means. Courts look at the effect of the book as a whole. In their entire context, not as detached or separate portions. And so selecting portions of a work, a material, will not allow you to say, well, just because of this portion, it must be obscene. You have to look at the work as a whole. When viewed as a whole, does it offend the common conscience of the community by present day standards? Miller versus California is the case that set that three-part test. The court has held that a standard to determine whether a material was obscene was whether the average person applying contemporary community standards, and contemporary community standards is a local assessment, not national standards, would find that the work appeared to the prurient interest, whether the work depicted sexual conduct defined by state law, and whether the work lacked serious literary, artistic, or scientific value. The court vacated and remanded the state court's decision in that case. To date, no Supreme Court decision has overruled the Miller test. So New Jersey has a case, State versus DeSantis. The New Jersey Supreme Court's definition provides a defendant could be convicted if the trier of fact found, this is convicted of an obscenity criminal statute, the material depicted or described in a patently offensive way, sexual conduct described above, to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeal to the prurient interest in such matters, and the material taken as a whole lacks serious literary, artistic, political, or scientific value. It sounds just like the Miller test because it has to sound just like the Miller test because Miller is the supreme law of the land. What's a community? The community standard is not a national standard, but rather a local one. In Wine versus Township of Irvington, the court discussed the state's involvement in the field of obscenity. State is our view that statutes on obscenity enacted by the legislature since 1957, and particularly in 1971, evidence a clear design for uniform statewide treatment of the subject. This was then invalidated. The court invalidated a Paramus Borough ordinance because the regulation of the matter of sale of obscene material was preempted by the state. The local standard that is to be applied, if codified, must be consistent with Miller. Again, they were saying it's got to be just like Miller. So what are examples of material? Patently offensive representations or descriptions of ultimate sexual acts, normal or perverted, actual or simulated, and patently offensive representations or descriptions of masturbation, excretory functions, and lewd exhibition of the genitals. Material that has serious literary, artistic, political, or scientific value will remain protected by the First Amendment, regardless of whether the government or majority of the people approve of the ideas these works represent. So in many ways, just like the Bill of Rights existed to protect the minority, the First Amendment continues to protect the minority, even where a majority of people may think that something is obscene. If it's not obscene per the Miller test, then it has to remain on there, even if a majority of people want to remove it. Sex versus obscenity. For legal purposes, sex and obscenity are not synonymous. They're not the same thing. Obscene material is material which deals with sex in a manner appealing to the prurient interest. The portrayal of sex, for example, in art, literature, and scientific works, is not itself a sufficient reason to deny material the constitutional protection of freedom of speech and press. Does the First Amendment protect obscene or lewd speech? The United States Supreme Court has found that obscene and lewd speech generally are of such slight social value that only a minor benefit is derived from such conduct, justifying the suppression in certain forums. Obscenity is not within the area of constitutionally protected speech because, again, it doesn't meet the Miller test by definition. So we've had a lot of recent cases that this has come up nationally. And again, we look nationally when there's a limited number of available cases in the state to give guidance, then we go and expand it to look nationally. These cases aren't precedential, meaning we don't necessarily have to follow them, but why we look to them is because just like there are smart people in New Jersey, there are also smart people in other states that have good arguments and reasons why they're making decisions. So we look to them to see maybe we'll agree with their rationales. So this case, Little versus Llano County, I think I'm saying it wrong, maybe Llano County, is a Texas Western District Court case. The public county library sought to remove children's books with messages not agree with, one of which was genderqueer. Books containing sexual activity or questionable nudity were removed. Specifically, one of the complaints was the depiction of the cartoon nudity. The court preliminarily determined the library's substantial motivation in removing the books appeared to be a desire to prevent access to particular views. So in that situation, they said, the analysis was subject to strict scrutiny, which is the highest standard when the government takes action, and the defendant had to prove that the removals are narrowly tailored to serve a compelling interest. That's a high standard, high burden to establish. In this case, the conclusion was that the removed books were required to be returned to the library. Now, that's the lowest level court in that state, so it may go up through the appeals. Two other cases in Ray, A Court of Mist and Fury, and in Ray Genderqueer, a memoir. These are two cases out of the Virginia Beach Circuit Court. A local resident sought to have the books banned from a public school district and the Barnes & Noble as being obscene for unrestricted viewing by minors. The court denied the motion to declare the books obscene and held that the plaintiff did not allege sufficient facts to support a finding that the books are obscene. Again, this goes to the standing issue with limiting access to books. There was a case out of Counts versus Cedarville School District. In this case, the local school district imposed a parental permission for accessing certain books. And the district court said that there was standing in this case. Ultimately, what they found in terms of their substantive holding was that the school board members who voted to restrict access to the books, in this case, the books were Harry Potter. Did so because they're concerned that the books might promote disobedience and disrespect for authority, and the fact that the books dealt with witchcraft and the occult. The court held that concerns over disobedience and disrespect were too speculative to justify the restriction of U.S. Constitutional Amendment 1. Regardless of the personal distaste with which the individual board members regarded witchcraft, it was not properly within their power and authority to prevent the students from reading it. The court therefore found that the students' First Amendment rights were violated, and the restriction based on the parent permission slip was invalidated. Again, State versus DeSantis, I mentioned that earlier. I'm going to jump past it. In New Jersey, we had a very recent case just out of March of 2023 in State versus Higginbotham. This case, the New Jersey's child erotica amendment to the endangerment statute was found to be overbroad because it unconstitutionally expanded the definition of child pornography to include images of children who were not engaged in sex acts, whereas the genitals were not displayed and regulated the private possession of child erotica. This case kind of tells you how far they go to protect the First Amendment, because normally you'd say, wait, the legislature passed an amendment to the child endangerment statute to basically outlaw certain child erotica, and the court invalidated it. And they invalidated it because it wasn't well defined enough. It was too vague, is essentially what they were saying. And so, again, it tells you how protective courts will be of the First Amendment. There have been some publications or published incidents of book removals in New Jersey recently. 3 schools had removed or limited books per September 22 article out of Westfield, New Jersey. South Hunterdon School District voted against removing school books. Washington Township School District removed Toni Morrison's Bluest Eye from its curriculum. It didn't remove it from its library. Glen Ridge Library decided against banning certain LGBT theme books that also made the paper recently. And so that is in general the presentation. We could go into a lot more, but I don't want to bore everybody.